Imagine standing in court, thinking you might get another chance. But instead, the judge starts reading your criminal history, and it just keeps going, and going. In this shocking courtroom moment, what begins as a routine probation hearing suddenly turns intense when the judge uncovers 12 prior convictions and drops a massive bond that leaves everyone stunned. Watch closely, because the next few minutes completely change this defendant's fate.
We now call 25 CR 519, the state of Texas versus Joshua Guidry. You are Mr. Guidry.
Yes, sir.
Present with Rife Kindler, your attorney and the state's attorney. There is a first amended motion to revoke probation that had been filed subsequent to an original motion that was on December 9th. And then this first amended is filed January 28th, about 3 weeks ago, two to 3 weeks ago. What are we doing today?
You gotta, if the court could go through the entire legal and please and request.
First amended motion to revoke. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Does he waive a formal reading of this? Can we proceed in summary?
So,
In summary, this first amended motion to revoke unadjudicated probation states that on August 7th, 2025, that in this court you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true?
yes, sir.
And that was a second degree felony, and you were placed on 10 years deferred or unadjudicated probation. Is all of that true?
Yes, sir.
Allegation. There are 9 violations. We haven't done this one. We hadn't had one state you committed the offense of public intoxication on or about October 10th, 2025 in Jefferson County. True. What is he? Well, let's
He's
just
not
say
pleading anything, evidently. I don't know why I'm going through this.
I think we've discussed it with him. I just want to make sure he knows.
is he going to plead untrue to the indictment? To the
Not
motion?
the entirety.
What? Okay, tell me.
We have to go through it. I don't remember because of the administrative violations that we're going to.
None of the substantive.
None of the substantive.
Okay, so the first 4 are crimes: public intoxication, PCP possession, public intoxication, and then number 8 is public intoxication, and 9 is public intoxication.
We were going to plead true to 5, 6, and 7. And then request a bond and then update a pre-sentence report and give the state an opportunity to prove up the other allegations. I don't know what the problem is with that. I mean, what?
Nothing except that he's just pled true to violating conditions of probation, which would be the same conditions he'd probably have as a bond. So why does he need a bond?
He's entitled to bond because it's so sure.
Well, it would be, but you just pled true to some allegations, so the judge can decide. He doesn't have to give him a bond after he's pled true to those. He could actually revoke him sending him to prison right now.
If you don't want to get out of this PSI, you can proceed on the administrative violations.
What do you want to do?
I would plead true to the administrators and request a bond. If Mr. Laird doesn't want to attempt to proceed on the substantive allegations, we can
We were
start
set-
the hearing today.
We were set for an announcement today. You want to set it for a hearing? We'll set it for a hearing. We'll have a hearing.
I'd like him to have a bond.
I know.
Give me that.
Well,
Yeah, I'm just trying to simplify things by going ahead and pleading to the administrative violations.
that's not simplifying things. It just, all it does is just makes it where you've got 3
Okay,
allegations.
what we're going to do is we're not going to take it in installments. We're going to do it all or nothing. Let's set this for a hearing. When can y'all be ready for a hearing? 2 weeks?
Yes, sir.
Could he
2
have,
weeks.
could he have a bond for that?
And on the bond, the court is reviewing. What does he have now? Is there a bond
There's
in that? Huh?
There's a bond.
In Mr. Guidry's case, Mr. Guidry, you know how many times you've been convicted. I mean, it's your life, right?
Yeah, but the PCP,
No,
No, that's That's what you're charged with. Here, phencyclidine possession. We're going to postpone that to another time. Talking about your criminal history. You know what your criminal history is. Okay. How many convictions do you have? 12. How can you know your life better than me? We go back to on 2011, failure to identify, giving false or fictitious information to police. You were convicted of a misdemeanor and confined. It looks like 4 days and probated for 6 months. In 2012, you were placed on deferred probation for 3 years for illegal possession of controlled substance. Later in 2012, you were convicted and sentenced to a theft, a Class B misdemeanor. And I'm not sure what the confinement is. I can't read it very well. In 2015, convicted of manufacturing or delivering a controlled substance and given 7 years probation. And in 2020, misdemeanor of DWI, convicted and sentenced to 90 days. 21, Class A misdemeanor, resisting arrest or search, convicted, and it looks like 10 days in your confinement. So that was Class A misdemeanor. Then a DWI, 30 days in jail. In 22, convicted, sentenced to 6 months in the state jail for illegal possession of controlled substance. 23, convicted, 20 days confinement, harassment of Class B misdemeanor. In October of 23, state jail felony, 6 months for illegal possession of controlled substance. In January of last year, 25, Class A misdemeanor, resisting arrest, confined for 30 days. And then in March of last year, second-degree felony, assault on a peace officer, and that's when you get this 10 years deferred or unadjudicated probation from me. So 12 times, and you've been handled, and you're currently on deferred or unadjudicated probation. You were convicted of all the others. Your criminal history is terrible. And now you are alleged to have committed drug offenses, public intoxication, etc.
But again, my suggestion is pleading to the administrator, you can get an updated pre-sentence report, come back for sentencing.
State has stated.
He's got new offenses. I mean, why do we skip those?
We're going to have a
Why would we skip them?
hearing on all of it.
Because then we get
Your bond is $250,000. Plus, if you post a bond, you're going to have a new testify. It says condition of bond.
I suppose you're only, this wouldn't have an updated PSI. What do you
Then
do?
we'll have a hearing
But then
in 2 weeks.
we have an updated PSI before the sentencing.
Maybe we'll see what happens. We'll see how that shakes out. Okay, thank you.
If this courtroom moment shocked you, wait until you see what happens in the next case. Real justice, real reactions, and unbelievable courtroom drama happen every day. Make sure you subscribe now and turn on notifications so you never miss the next jaw-dropping moment caught on camera.